5 seconds to go. Start. The factual background in which the aforementioned issues have been raised are that petitioner of present writ petition was appointed as a fair price shop dealer in the year 1993. Petitioner's son Raj Bahadur was elected as Pradhan in the year 2010. A show cause notice dated 5th November 2012 was issued to the petitioner to show cause as to why the shop be not cancelled, since he is running the shop living in the joint family and his son has been elected as Pradhan. Petitioner submitted reply to the show cause notice dated 31st January 2013, and same was followed by the order dated 3rd April 2013, by which petitioner's fair price shop agreement has been cancelled. Petitioner at this juncture has approached this court questioning the validity of the decision so taken cancelling his fair price shop agreement on 3rd April 2013, and his submission has been to the effect that petitioner's son is living separately and cannot be treated to be a member of family, and accordingly ground on the basis of which petitioner's fair price shop has been cancelled is unsustainable. Petitioner's submission has been to the effect that the definition of family as given in government order dated 3rd July 1990 and as has been interpreted in Ram Murat's case Supra does not take into consideration clause 2O and further clauses 30 and 31 of UP Scheduled Commodities Distribution Order 2004 in its correct reference and correct perspective, and in view of this, the definition of family contained in Government Order dated 3rd July 1990 has to be accepted as superseded and effected after the enforcement of UP Scheduled Commodities Distribution Order 2004. The division bench of this court noticed the arguments raised from the side of petitioner and proceeded to refer the matter in the direction of getting authoritative pronouncement. Shri Ajay Behnot, learned counsel for the petitioner, opened his arguments by contending that the division bench's judgment in the case of Ram Murat Supra, by accepting the definition of the word family as given in Government Order dated 3rd July 1990, paragraph 4.7, has not at all laid down the correct law after enforcement of UP Scheduled Commodities Distribution Order 2004, wherein a different concept and a different definition has been introduced in the shape of household, which is synonyms to family, and in such a situation definition of family as mentioned in Government Order dated 3rd July 1990 has to be accepted, and accordingly by placing reliance on the definition of family as given in paragraph 4.7 of Government Order dated 3rd July 1990, such a punitive action could not have been taken as has been done in the present case, and the issue in question ought to have been dealt with on the parameters of the definition of household as is provided under clause 2O of in UP Scheduled Commodities Distribution Order 2004, as same has the overriding effect over the definition of family given in paragraph 4.7 of the government order dated 3rd July. The admitted position is that the assignments of work under the roster prepared under the directions of Honorable the Chief Justice changed after the summer recess of 2013. However, the same learned single judge who had heard the matter on 9th May 2013 and 20th May 2013 heard the proceedings on 10th July 2013. For the first time, notice was issued on that date when the Learned Standing Council representing respondents 1 to 7 and the council representing respondents 11 and 12 accepted notice. The appellant, being an officer of the Education Department, the Learned Standing Council, was directed to take notice on his behalf. A further direction for listing the matter on 25th July 2013 was issued. Thereafter, the learned single judge heard the petition on diverse dates between 25th July 2013 and 10th October 2013. Eventually, on 25th November 2013, an order was passed by the learned single judge observing that the court was satisfied that there had been an attempt on the part of the then regional joint director of education to overreach the directions issued by this court in a judgment dated 22nd October 1997 and to bring disrepute to the final judgment. Consequently, the then regional joint director of education was prima facie held liable for contempt and his presence has been directed to be secured before the court on 18th December 2013 for framing of charges. Two submissions have been urged in support of the appeal. First, it has been submitted that under the directions of Honorable the then Chief Justice, the hearing of the petition was directed to be laid listed before the appropriate bench. Accordingly, the petition came up before the learned single judge on 9th May and 20th May 2013. This was before the issuance of notice. Once the roster changed after the reassembling of the court at the end of summer recess in July 2013, it has been urged that the learned single judge had no jurisdiction to further proceed with the hearing of the petition and hence the assumption of jurisdiction was improper and the order which has been passed on 25th November 2013 is a nullity. Second, it has been urged that even if the assumption of jurisdiction was correct and proper, the learned single judge had no jurisdiction to hold the regional joint director of education prima facie liable for contempt and to require his presence for framing of charges since the learned judge was not assigned contempt matters. On the other hand, it has been asked on behalf of the respondents that the learned single judge had heard the matter in part on 9th May 2013 and consequently was acting within jurisdiction in continuing to retain control over the matter despite the change in the roster. Once the petition was heard in part, the learned single judge was justified in entertaining the petition under section 15 of the Contempt of Courts Act 1971. The court has jurisdiction to take cognizance on its own motion of a case of criminal contempt. Stop.